Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Varity Law.
When someone passes, most of their assets will be immediately frozen. Their executor or his or her lawyer must apply for court approval to get the assets unfrozen and passed down to the beneficiaries. This necessary process is called probate.
Recently, clients have contacted our office to apply for probate when the deceased had passed several years earlier. This is not good at all.
That's right. Delaying probate will likely result in much higher costs, even longer processing time, and sometimes the complete loss of your claim to the estate.
Those are very serious consequences. Today, we will address 4 reasons why you should start probate as soon as possible.
Number 1, to delay creditors selling the estate assets. Most people are unable to pay off all debt during their lifetime, including their mortgages and line of credits.
This means that those debts must be paid out at the debtor's date of death using money in the estate. Luckily, if the estate does not have enough money to pay off all of the debts, then the creditors cannot go after the debtors' families and must eat this loss.
That's right. And that is why most creditors are smart and require a collateral.
Exactly, like registering a mortgage on a house. Any collateral with a registered debt is called a secured interest, meaning even if the borrower dies, but the collateral is still there, then the creditor can sell the collateral to recover their investment.
So in the example of the house, under the Mortgages Act, the bank is entitled to start power of sale procedure after the borrower defaults for 15 days or more.
Now do be careful here. Default means the borrower did not follow all of the rules per the contract they signed with the bank. Interestingly, the borrower dying can be considered a type of default.
This means that within 15 days of the borrower's death, the bank may start power of sale, with all realtor and legal fees being paid by the estate.
That is absolutely horrible. Luckily, although the banks can sell the house after 15 days, most will wait for a couple of months. Also, this process can be delayed further if you've already started probate.
In most cases, if the executor can provide a letter from the estate lawyer stating that probate application has been submitted, then the banks will wait until probate is approved before taking legal action.
The good news is that once probate is approved, the beneficiaries can either reapply for a new mortgage or sell the house. In either case, they would have the funds to pay off the old mortgage under the deceased's name, and the bank would not need to start the power of sale at all.
Exactly. So starting probate early is good to delay creditors from selling the estate assets.
Next, there's the issue of bond insurance.
Yes. Whenever the estate court thinks there is a high risk of estate assets being mismanaged, then they will require the executor to buy a bond insurance policy. This can cost up to 5% of the entire estate value. So for a $1 million estate, the bond insurance payment would be as much as $50,000.
Whoa, that is very high.
For sure. So John, in what situations would the court require a bond insurance?
Well, there are many situations, but it all comes down to 3 primary worries. First, the court has doubts about who the correct beneficiaries are. Secondly, the executor is not good at locating and managing the estate assets. Or third, the executor will not give the beneficiaries all of their inheritance.
Today, let's focus on the issue of locating and managing the estate funds. The longer probate is delayed, the harder it is to locate and manage the estate funds and assets.
For sure. Let's take the example of a house. If no one is being appointed as the executor and the estate property is not being managed, it will deteriorate.
That's right. The necessary repairs and maintenance won't happen. Not to mention, a house that is vacant for a long time is more likely to be robbed and damaged by others.
Also, the necessary daily expenses of the house, including property taxes and utility bills, must be paid on time. Otherwise, penalties will stack up and reduce the value of the house.
Another example is a bank account. Many executors are unsure how many bank accounts the deceased had and the balance in each one. However, if the executor tried to discover all bank accounts shortly after the deceased's death, they can usually access the information by going through the deceased's mail for bank statements.
But the longer the executor waits, the harder it is to locate and ascertain the value of all bank accounts owned by the deceased.
Also, tying back to the bond insurance, because the court knows that it is harder to locate and manage the estate assets when probate is delayed, they will likely think any executor who took forever to file probate application is irresponsible and risky.
A risky executor means the court is more likely to require bond insurance, costing up to 5% of the entire estate. After the executor contributed this money, the court believes they have more incentive to distribute the estate properly and correctly and will pay estate taxes on time.
John, is bond insurance paid on a one-time basis?
Unfortunately, no. The bond insurance must be renewed at the end of the term, and the 5% can be required continuously until the estate is fully distributed to the beneficiaries. So, the longer the executor takes to get probate approved and finish distributing the assets, the more insurance payments will be needed.
Next, immediately after the deceased passed, a series of important decisions must be made by the executor.
For example, funeral decisions. What if some family members want the deceased to have a traditional burial while others want the deceased to be cremated?
If the funeral home is unsure of who can make the funeral decisions, aka who is the executor, then that puts them in a very difficult position. The longer this dispute drags on, the harder it is for the families.
In this case, it's best to first have a valid will that clearly states who the executor is, and second, of course, getting probate done as soon as possible.
Another decision is who can respond to other parties when it comes to legal decisions. Most commonly, if the deceased has creditors, who can respond to creditors in order to delay their selling of estate assets or filing lawsuits?
The person responding should be the executor or their lawyer. Also, if the deceased is a party to a contract, most commonly pre-construction purchase agreements, then who can respond to the builder when they ask how to proceed?
Again, it will be the executor or their lawyer. But a court approval document must confirm who is the executor, and you can only get that with a successful probate application.
As well, if you oppose the will or the probate decision, you must bring a claim within 2 years of the deceased's passing. Let's say Sarah was married to Steve, but he did not leave anything to her in his will.
If Sarah wants to dispute this, then she can use family law to get part of Steve's assets after he passes. But the family law claim must be brought within 6 months of Steve's death.
If Sarah wants to dispute the estate by using other reasons, such as unjust enrichment, then she must sue the estate within 2 years of Steve's passing.
Exactly. The recent case law of Ingram and Kleinage estate confirms this once again. The court ruled that the 2-year limitation period applies, and the girlfriend can no longer sue for unjust enrichment 4 years after the deceased's passing.
Okay, let's summarize the 4 reasons why probate applications must be submitted early. Number 1, to delay creditors from selling the estate assets. If they do start power of sale, then the realtor and legal fees would be paid by the estate, and we do not want that.
Number 2, to reduce the chance that a court may ask the executor to buy bond insurance, which can cost up to 5% of the entire estate. Also, to avoid not being able to locate and manage estate assets like real estate and bank accounts. Mismanagement will result in the loss or depletion of the beneficiary's inheritance.
Number 3, to ensure the executor is appointed and authorized to make immediate decisions, such as funeral arrangements, responses to creditors, and responses to the builder if the deceased signed a pre-construction contract.
Number 4, if you disagree with the will or the probate approval document, you must bring a claim within 6 months of the deceased's death if you're claiming under family law, and within 2 years of their death if you're claiming under estate law.
Now, there are actually 4 more reasons why probate should be done as soon as possible, which we'll cover in our future video.
That's all for today. We will see you in our next video.